We want to take you live outside the Kenosha County Courthouse. We did capture on video a short time ago. There was a dust-up, a fight, according to Bill Miston, on the steps between the two sides. But deputies have moved in and broke it up. Seems things have calmed down. But we're watching this closely as those people on the steps there wait for a decision in the Kyle Rittenhouse trial. The second full day of jury deliberations with more questions from the jurors to the judge and another request for a mistrial. Joining us live, Michael Hart, defense attorney with Hart Powell SC. Attorney, great to have you back. And despite no verdict, plenty of drama in the courtroom. I want to ask you about this fight over drone video. I mean, all the evidence has to be shared, right? And prosecutors say they emailed over this drone video to the defense. And now the defense says they didn't get the same quality of video that prosecutors have. I mean, when you email something, it can compress the file, and that's possibly what happened here. Is this enough for a mistrial?
Might be. If the prosecution acted in bad faith, that's going to be the ultimate question. I think the judge indicated, kind of a foreshadowing, hey, Mr. Binger, things better check out as you have represented them. And if they do, then the evidence will remain, and I suspect the mistrial, at least on that grounds, will be denied. But if it turns out that he knew or held something back or in some way gave the defense something less than they were entitled to, then that might be a problem for him.
And they're fighting over video quality here. You're a defense attorney. Why? I mean, it's not that the video per se would be different what it shows, but the quality might be different. Is that an issue, how you see it?
Well, it's not an issue any longer. The enhanced video is what's in evidence. So the jury, in asking to view the evidence, can only see what's the copy and the quality that's in evidence. The time to object to that was before the evidence was introduced and received. My understanding is that the defense at that time, perhaps under the misimpression that they had the same evidence as the state had, didn't object.
If granted, this would be a mistrial without prejudice. Can you explain that for us? I mean, if granted, it's basically a redo, right? They do this over.
It means the state can recharge Mr. Rittenhouse. With prejudice would preclude a second prosecution. The double jeopardy clause that both the U.S. Constitution and the state Constitution prohibits a person being charged and tried a second time. So without prejudice means that there were grounds for a mistrial, that Mr. Rittenhouse didn't receive a fair trial, but that it was not as the result of some intentional misconduct on the part of the state.
And we have seen another request for a mistrial with prejudice. We won't get into that issue, but that's something else that's still dangling out there for the judge to decide. All right, it's been about 15 hours of deliberation. We know the jury asked to see a video replayed again. 15 hours. Is it safe to assume they're not all seeing things the same way back in that room?
Well, it's safe to say that they're talking about something. It's probably safe to say that they're giving a fair and thorough analysis of a lot of evidence in a very, very important case. It signals that the jurors appreciate how serious and solemn their job is here, and they want to do the right thing. I think it's safe to say that.
You're a defense attorney. The longer this goes, is that a good or a bad thing for Kyle Rittenhouse?
Well, that's always a tough question to answer. I would say that if they were going to acquit him based on self-defense, they probably could have done that in less than 15 hours.
Interesting. Hey, it's been another day and another. Go ahead. One more thought.
That's not to say that they ultimately won't reach that verdict, right? But I think conventional wisdom on the part of those people who thought the prosecution hadn't proven their case was, if they were going to find that he acted in self-defense, that his conduct was reasonable, that could have been done in sooner than 15 hours for sure.
Well, this will all get cleared up soon, possibly. We'll see how long this goes, and we'll keep calling you and bringing you on until we do get that verdict. Michael Hart, defense attorney, appreciate your time.
Always been. Thank you.